Hi. In my position as a legal assistant for an attorney, I am asked every day what the steps are of a medical malpractice going through the system. So I thought I'd take a few moments and give you some ideas on how medical malpractice runs through our legal system. I work for an attorney that is a plaintiff prosecuting attorney. So what he has to do is prove what actually happened. So he asks the client many questions before he'll decide whether or not it is something he wants to pursue. Once we do make a decision to pursue a case, the first thing we do is obtain all of their medical information. We will contact every hospital, facility, physical therapist, physician, chiropractor that they've had and get all those records. To put a case through in Michigan, you have to have an affidavit of merit from a doctor. So we always have to find experts in their field to sign these affidavits of merit. We will send the physical summary to them and they will make a decision on yes, it is a good case or not. To be an expert in your field in Michigan, you have to have served as a physician for the past 12 months in that field and be board certified. Once they're able to have gone through everything, they will say yes or no, this is a good case. If they say yes, we have them sign an affidavit of merit. In the meantime, we send out notices of intent to each of our defendants, which is the other side of the coin. We will say, we are going to sue you. They have 190 days to respond. Within 156 days, we have to hear what we call an appearance, which is an attorney that says, yes, I am going to take care of this for this customer. Once we receive an appearance, we are able to serve them. We send out a summons and complaint. A complaint is basically telling the courts what happened, what we expect, and the summons goes along with that, and you get served this. Along with the summon and complaint, we also send discovery to them. Discovery comes in two forms. One is interrogatories and one is production of documents. Interrogatories is about 100 different questions that we ask. And production of documents is basically that, asking them to produce all documentation that they have on our client. Once this is done, because the courts are so backed up in Michigan, they will send you to a case evaluation. Case evaluation is where 3 attorneys, one from our side, one from their side, and a neutral attorney get together, listen to both sides of the coin, and decide whether or not they think the plaintiff should get some money or the defendant. If the plaintiff receives the money and the defendant agrees on it, both sides have to agree within 28 days. It's finished. We're done. If that does not happen and one does not agree, we are then sent to mediation. Mediation is just like it sounds. There's a mediator, normally a judge, a past judge, or an attorney that's willing to mediate. If they are willing to mediate, they will be the mediator. Both of the attorneys then will share their sides, and then they start bargaining back and forth. Both the attorney for the plaintiff, attorney for the defendant, plaintiff and defendant are at this meeting. So they will say, I'll give you this. They will say, nope, I won't take that, and go back and forth. If after mediation there still is no reconciliation of this claim, it will then go to court. Trial is extremely expensive, and so most clients will try to avoid that. Every penny will come off their bottom line. So we ask, most often, they are taken care of in mediation or case evaluation. Very few go to trial. If so, trials last about 3 to 5 days depending upon the case. And the problem with that is if you lose, you gotta pay. So most people don't want to go. And that's pretty much how a medical malpractice suit goes through the system. Thanks.